Welcome back to the Vault. Hi, I'm Michael Cole. Let's talk about a nightmare scenario that plays out in indie film distribution every single year. You wrap principal photography on your passion project. During prep, your DP, production designer, and post supervisor agreed to work for low upfront cash in exchange for small deferred pay and a few back end points. 2 years later, you secure a distribution deal, and suddenly your key department heads show up demanding back end payments directly out of early sales revenue before your equity investors have even recouped a single dime. Worse, when your sales agent audits your files, they see that your crew only signed a quick one-page pre production memo. Your chain of title is a mess, your investors are furious, and your distribution deal collapses. Without a long form agreement, loose back end promises turn into production halting lawsuits. You need the department head or producer's long form agreement. This document locks down work for hire structures, your waterfall, and cleanly replaces preliminary crew deal memos. So, before we dive in, let's go over our typical disclaimers. First and foremost, this is for educational purposes only, and it is a drafting tool and a starting point for independent filmmakers. It does not constitute legal advice, legal representation, or legal opinion on any specific facts or circumstances. Second, no attorney-client relationship is formed when by downloading, reading, or using this template between you and the NonDē filmmaking legal lab. You're not a client of the lab, and the lab is not acting as your legal counsel. Third, jurisdictions and variations matter. This template is drafted on basic general principles of United States contract law and common industry practices. It is strongly advised to have local counsel review the document. What works in New York might not work in California, might not work in London, might not work in Sydney. Fourth, use this at your own risk. By using this document, you acknowledge that you are doing so using this at your own risk. The NonDē Filmmaking Legal Lab takes no responsibility or liability for any errors, omissions, or legal consequences. And now just some quick usage notes. So when do you use this agreement? First and foremost, you use this for department heads, your DP, production designer, post supervisor, or above the line producers who require a comprehensive agreement covering deferred fees, back end profit points, and complex credit placements. Also to note, the waterfall shield, Exhibit A. Exhibit A is an exhibit that is attached to this agreement, and back end points mean nothing without a strict definition of the waterfall. So Section 4 and Exhibit A strictly work together and limit back end participation to the producer's pool, preventing key crew from claiming points against gross sales or investor capital recoupment. Then investor priority. Exhibit A again prioritizes your equity investors over crew deferrals. Investors recruit their capital plus their premium prior to any deferral payouts. Dual status. So 1099 versus W-2. There's generally a tax conflict that happens, and so Section 9 classifies the contractor as a statutory payroll employee for tax and workers' comp purposes while strictly maintaining their independent contractor status for IP creation and corporate liability, meaning that you protect yourself in the chain of title. And then this integrates previous memos. Section 16B includes an explicit superseding clause. So if you had someone sign a quick one-page crew deal memo during production, this long form agreement clearly and cleanly swallows that agreement and replaces the memo without creating any conflict or contractual liabilities. So let's dive into the actual agreement. Here with this agreement, you'll see that it's a little bit more comprehensive. You have some more preliminary information like the date, who the producer is, their address, and their email address. You'll see this is important later for notices down below, as well as the department head or the producer, their address, their email address, and it regards the picture. Then we have recitals. Recitals provide context for any contract. And so whereas the producer intends to produce the picture currently titled X, and the contractor is experienced in the industry and desires to render services as a producer or costume designer, whatever department head, whereas the parties desire to set forth the full terms of this contractual agreement, including payment, back end participation. Now, therefore, in consideration of the mutual covenants below in this contract, the parties agree to the followings. So Section 1 clearly establishes our definitions. This is where you want to put in any important definitions that you may require as a production. We've put in the three most important definitions here: gross receipts, which shall mean 100% of all non-refundable, non-returned monies by the producer. Then production costs, all direct out-of-pocket costs. And then net profits shall have the meaning set forth in Exhibit A, aligning with the distribution waterfall. Before we move on to section 2 and other parts of the agreement, we are going to look at Exhibit A. So let's scroll all the way down. Here we are in Exhibit A. Exhibit A, like I said, is going to be its own page. It's going to be attached to the back end of the contract. And this spells out our waterfall. So for this long form agreement, you need to look at this waterfall. Tier 1 is off the top expenses. Tier 2 is guild residuals and corporate liabilities. Tier 3 is your investor capital recoupment plus their premium. And then Tier 4 is where your crew deferral pay will go. You can cap it. Even if you cap it here, you need to put that in. And then Tier 5 is your net tier split, where any back end points will be paid out of. Additionally, on Exhibit A, we have certain accounting and audit rights, which we'll talk about later. But for all intents and purposes, net profits are defined in Tier 5. The remaining balance, if any, shall constitute net profits. 50% of net profits shall be allocated to the investor's pool, and 50% shall be allocated to the producer's pool. And the contractor shall receive their designated contingent compensation percentage strictly calculated from paid out of the producer's pool. So this says what exactly net profits is. So let's dive back up to section 2. Sorry, this is a longer video because this is a much longer and comprehensive contract. So this is for your engagement of services, how long, they're non-union, you have no obligation to produce. This is your compensation clause. It basically spells out what you owe them. So the cash compensation that you're going to pay them, where you're going to pay it through, generally a payroll processing company, and then deferred compensation. This is not points. This is just if you wanted to give them additional compensation because they're taking low cash up front. This is where the deferred compensation would come in. Section 4 is your contingent compensation. So this is your back end points. So this is where you would provide them with a number, say 2%, i.e. 2 points of 100% of the producer's net profits. And it is contingently defined in Tier 5 of Exhibit A. Again, no contingent compensation shall become due until the pitcher achieves net profits, which is Tier 5 Exhibit A, and the contractor agrees to execute any standard documentation required by a CAMA account, basically a professional account that will take your money and disperse it to the appropriate individuals per their proper percentages. Section 5 is your typical credit clause that allows for no inverted failure, but states that you as a producer will fix it if needed. Section 6 is your name and likeness. Section 7 is your work for hire. So remember, with work for hire, you always want to have that it is a work for hire, that you are the exclusive owner in perpetuity and throughout the universe, and that if anything isn't a work for hire, you will the individual will sign it over. And then finally, what's different here is we have attached Exhibit B. Exhibit B is our certificate of authorship. It's best to get this signed when you're getting signed the long form agreement. So we'll jump down to look at that real quickly. Exhibit B is a certificate of authorship. When you are working with distributors, they want to see that you have proof that you have ownership and a clean chain of title. And rather than sharing them your intimate contract with all the details, you just share with them this one-page document that your department head has signed that says, I am the department head and I waive all ownership. The LLC, the producer's company, owns the project. And this is what you would actually share with your distributor so that they don't have all your private details and you can get a much fairer offer. So now let's scroll back up. We're in termination and suspension. These are the various clauses for termination and suspension and can be adjusted as needed. Generally, you want to have a morality clause, you want to have a disability and force majeure clause, and then you want to have the effective termination. Section 9 is that dual tax status. So it clearly separates you as a worker with workers' comp, but it clearly affords the protections of IP as an independent contractor. You want to always have a code of conduct and anti-harassment policy because you are a business and you want to follow national guidelines. So this is that. Here's a unique provision, the personal vehicle and indemnification clause. If the individual is a local hire and they'll be using their own vehicle, you want them to indemnify you from anything that they do while they're driving. So this basically states that you will not be held liable for anything that happens while they're in their car. Section 12 should look familiar. It is our no injunctive relief clause. Basically states that the film can't be stopped from being released, but you can be sued for damages. Severability and assignment. This basically says that if anything in the contract is deemed invalid, just that section is invalid. And assignment states that allows you as a producer to assign this contract to a distributor and or a single purpose vehicle. And then finally, section 14 notices. This is important. So in this individual agreement, there are different sections that require notices saying to cure a defect, to cure credit problems. And here, this notice states that email is an acceptable notice, but it has to be the email at the top of the contract, or mailing notice, but it has to be the mailing address at the top of the contract. And then sections 15 is our general governing law and jurisdiction. So whether it's New York, California, it's our jurisdiction of what county you want the court to be heard in, and then waiver of a jury trial. You want a judge to hear this. You want it to go fast track. You don't want to have to deliberate with a jury. Section 16 is the entire agreement and merger that basically states that anything in this document is the document, anything outside of this document is not the document, and that any document signed electronically will be deemed as signed with a wet pen signature. And then finally, the most important part of this section is section B, the superseding clause. So if you have signed any previous crew deal memo, this document absorbs that. You put in the date of that deal memo here, so this contract can point back to that contract and state that it overrides it. And now this is your brand new contract. You sign it as the producer, you have the contractor sign it, then you go through your waterfall, make sure they understand it. Accounting rights and audit rights basically states that they can audit you once a year with a certified public accountant, but they have to pay for all costs. And if you do realize that you're underpaying them, you might have to pay a penalty due to the fact that they had to pay for an audit. And then we have our certificate of authorship. Again, this is that one pager that you want them to sign so that everything gets buttoned up. So this is the department head and producer long form agreement. It's how you lock down your intellectual property, protect your investors, your waterfall, and clean up your chain of title. Your next steps: download the template. There's a link below. Execute the long form, replace those pre-production deal memos before you step into post-production, and get the certificate of authorship. Pair this contract with the certificate of authorship for a tight chain of title security. Stop gambling your investors' money on generic templates, and it's time to secure your armor. Let's get to work. Have a great day, everyone.